Rast-
Greetings, brethren and sisters. This is Gillie Priest of Gillie Priest Revolutionary Radio and Channel. Today, I will bring forth a presentation and an historical document because over the months that I've been in Jamaica, I've been making reference to this particular document. And since then, a lot of brethren and sisters and subscribers have contacted me and asking me about this particular document. And it is a document concerning the judicial constitutional recognition of the Rastafari way of life throughout the United States. And it has become the bedrock foundation of the Rastafari rights established throughout the United States. And a lot of time today when you see in the United States, and when you speak of the United States, you otherwise you're speaking in terms of what Babylon referred to as the free world. Because the free world, which is when them call free world, which is usually mean the European countries, they look to the United States where certain democratic rights are pushed and given recognition to, so they can further extend it throughout the Western Hemisphere. And the case I'm making, this document I'm referring to, is a case where the Rastafari brethren in the New York State penal system challenged the court and the Department of Correction to give recognition to the Rastafari way of life, because from the late 60s to going up into the early 70s, mid 70s, Rastafari brethren from all over the Caribbean, but mainly from Jamaica, started to get pulled into the penal system in America. And as a people who carries our way of life with us, as a people who brings our culture along with us wherever we go, we encounter protagonists in our ways who try to prevent us from living the way we choose to live. Or they may choose to, because of a lack of understanding, direct a sense of mockery towards our way of life. So we stand up, right? Another thing I'd like to point out was that in this struggle, while we was in the New York State penal system, one of the most pointed recognition I would like to point out to the brethren and sisters is that the brethren who fought the struggle to get recognition for the Rastafari way of life in New York State, and by extension throughout the entire Union, it wasn't the brethren and sisters who come in who had a strong sense of academic background, you know. Because what I've recognized that a lot of the brethren them who have a sense of academic background mean that they may have finished high school, attended colleges and universities. A lot of them have this tendency to look down on their less academic achieved brethren and sisters. Yet, when there is something to be done in struggle, all they do is use that academic background that they have to criticize the brethren and sisters who don't have it. And I'm making this fact to point out that what I want to give recognition to is that the majority of brethren who move the Rastafari struggle forward to where it is now continentally recognized throughout the United was the brethren who didn't really have no illustrious academic background. And the same thing we see in society from ancient days is the people who are most oppressed, the people who are most denied, the people who are what the society would recognize as being illiterate, and those who are functionally literate. These are the people who tend to push the banner forward, push the struggle forward. Yes, leadership at times is given by the better off, well, most educated, but they usually come in after the struggle has reached a boiling point and try to bring the academic background to temper the struggle instead of pushing the flame forward, throw gas on the flame to move the struggle forward. So this case that I've always constantly make reference to and has always given recognition to Jaboni, the badass out of England, as one of the main figures in moving the struggle forward. So I went spend some time today reading this case, and as I read this case and go forward, I'm going to kind of give a little explanation when necessary. Now, anyone who want to look up this case on the internet or whatever, the name of this case is Benjamin versus Coughlin. Benjamin. Then for the versus, you put a V, and then you spell out Coughlin. Coughlin. Now, why is the name of this case Benjamin versus Coughlin? What usually happens, for those who have a semblance of knowledge of a class action is when a group of people comes together and file a civil complaint in the court stating that they are all suffering similarly under the law as it is being established, whether by omission or by commission, whether the state and the government fails to do something or whether they are doing something that they should not be doing. So when a group of people comes together and file an action in the court based upon similar actions being suffered, that is what is referred to as a class action. Now, those class of people, let's say 10 people, put their name on a piece of paper and file a complaint in the court stating that their right to practice their religion or the right to practice their spiritual way of life is being denied or obstructed by the state. Then if the court give recognition by saying, okay, we will listen to that, it means that the court has recognized that there's a class of people, there's a group of people that are suffering similarly by act of omission or commission as alleged against the state, as alleged against the government. So what happened is, some brethren in the system came together, and usually the court will select, say 20 people sign this complaint to the court. The court will select, let's say 10 of the names or 6 of the names as a representative of the class, meaning they don't want to keep typing out on a sheet of paper 100 names or 20 names or 40 names. So they usually select the first top 5 names to represent the entire class, and that entire class usually means people who suffer similarly from an act of omission or commission by the state throughout the entire United States of America. Those 6 people will. So why this case named Benjamin versus Coughlin? And let's recognize those 2 names as 2 surnames. The Benjamin is the last name of the first person that was placed on the complaint. So if there are 10 people filing the complaint, the first person that signed the document in this particular situation, whether they signed it alphabetically or they signed it as somebody come along and say, I would like to sign, this person's last surname was Benjamin. In this instance, Benjamin is representing the plaintiff. Benjamin is representing the class of people that this particular case represents. Now, Benjamin versus Coughlin. Coughlin is the name of that person who is going to represent the defendant in this case. The plaintiffs versus the defendant. The plaintiffs were us, the prisoners who were incarcerated in New York State, versus Coughlin, who is representing the state and the Department of Correction. So it is the prisoners versus the state. Now, how do you look up this case? How do you go into a library and find this case, Benjamin versus Coughlin? You can go in there and maybe just plug the name in. Benjamin versus Coughlin, and a lot of cases may come up with similar ones. So you have to narrow it down now by if you have any knowledge of when the year took place. Or you could just scroll through the case and see that this case is about Rastafari. If you don't have the name, or if you have the name, there's additional information. And this case is cited in all legal documents as Benjamin versus Coughlin. The volume of the book that you can find it in is volume 708 of the Federal Supplement. So when you see federal supplement, this is telling you that it's coming from the district court level, the trial court in the federal government of the United States. So the volume of the book is 708 Federal Supplement. And when you get that volume, the page that case begins on is page 570. So overall case, Benjamin versus Coughlin, volume 708 of the Federal Supplement, page 570. This case also came out of the Southern District of New York. The federal courts in the United States of America are broken up into districts, meaning basically regions. So this one comes out of the Southern District of New York and came out 1989. Now, why 1989? You got to remember, when you file a case, a typical case in the United States District Courts, there are a lot of procedural motions that take place before this case can begin trial. Sometimes it takes years, 3, 4, 5, sometimes 7, 8 years before the judge and the plaintiffs and the defendants all agree that they are ready for trial. Okay. March 1989. March 13th, 1989. And I'm going to read now from this document, the case. Thomas, Benjamin, these are some of the plaintiffs' names that was selected on the legal document. But there were hundreds of people who signed this document. And this complaint represents the millions of people in the United States who would like to take advantage or suffer some consequences that can be implicated by the complaint that was made in this case. So the guy's name is Thomas, Benjamin, Errol Dunkley, Frank Forrest, Barrington Gray, Newton Annan, and Martin Spence on their own behalf and on behalf of all other similar situated plaintiffs. These are the names that the court selected from the hundreds of us that signed the document. These names are basically selected because these guys are the ones that first signed the complaint. So when we sat in the prison and decided to go to court and decided to pass around the document and ask brethren to sign if they're willing to go in the court as a complainant, these were the guys that first signed the document, but there are hundreds of the other names underneath it. The court is not going to print out the hundreds of names that signed it, so they select maybe the first 5, the first 6, the first 10 and say, this group of prisoners will represent all prisoners throughout the United States and everyone else throughout the United States who shall have a complaint that can fit up under this. So it's versus, right? So remember, Benjamin versus Coughlin. Now let's see who Coughlin is representing in this case. His name is Thomas A. Coughlin, and he's a commissioner for the New York State Department of Correctional Services. He's also represented in this class action Stephen Dalashim, the superintendent of Sing Sing Correctional Facility. Eugene S. LaFerry, superintendent of Clinton Correctional Facility. That was where I was at. And Harold Simmet, superintendent, Attica Correctional Facility. Now, these guys who are representative of this government, representative of the state, representative of the Department of, they are the defendants in this case. Prisoners versus the state. This again in the United States District Court. Also involved is the Prisoners Legal Service of the New York State, Poughkeepsie, for the plaintiff. So the legal representative for us, the guy with the legal degree, who was basically going to stand there and make sure that the proper procedures and legals are adhered to both by the plaintiff, us, and the defendant, the state. Prisoners Legal Service of New York was from Poughkeepsie, New York. That's the office that we use. And his basic name is Robert Selcor, Stephen Latimer of counsel. So these are the two legal representatives involved. The lawyers, which are the the Attorney General Office, who represent the defendants, who represent the government, who represent the state, name was Robert Abrams, Attorney General of the state of New York, Albany, for the defendants. And the guy who actually came into the court to deal with the case was Tarquin J. Bromley of counsel. So there you have the defendants and the plaintiff. There you have the counsel who's going to represent us, the plaintiff in this case, meaning the prisoners, and the Attorney General who is representing the state of New York, the government, and the prison department. Now, this is the opinion and order of Stanton, Judge Stanton, from the district judge. And this is his argument that he's writing out now, making his ruling. After the trial, he's going to lay out the whole historical argument that's been made, that's been put forth judicially, constitutionally, and he is heading it up here by saying the opinion and order of Stanton, Judge Stanton, the district judge. Here we go. Plaintiffs are Rastafarian inmates in the custody of the New York State Department of Correctional Services. Rastafari is a religion with roots in Jamaican culture. It has no hierarchy of religious authority, although Rastafarians recognize some who have studied the religion extensively as quote-unquote elders, and no single religious text setting out the central tenets of Rastafarian belief, although Rastafarians consider certain Bible passages sacred. There are several Rastafarian sects with different beliefs and practices. The most widely accepted Rastafarian principles include beliefs in the divinity of Ethiopian Emperor Haile Selassie and that the hair and beard should never be cut. Many Rastafarians wear their hair uncut, uncombed, and called quote-unquote dreadlocks. Many believe that the dreadlocks should be covered at all times except when praying, and wear a religious quote-unquote crown, a loose knit or crocheted head covering to protect their dreadlocks. Rastafarians engage in dialogues about the meaning of scripture known as quote-unquote reasoning, and conduct weekly group services that last from few hours to several days. They also hold religious celebrations on Haile Selassie's birthday and on the anniversary of his coronation. The green, red, and gold colors of the Ethiopian flag and the lion, which symbolizes Haile Selassie, are sacred symbols. Many Rastafarians follow what is known as an ital quote-unquote diet, abstaining from meat, liquor, and caffeine, and eating only natural food, although there are variations in these practices. Now, these facts, quote-unquote facts that the court is laying out, these facts are drawn from testimony that was given at the trial by people who the court had declared expert witnesses. One of the most fundamental expert witness that put forth some of these facts to the court is Badass Jaboni in England, who testified in this case, who was declared by the government of the United States to be an expert in disseminating Rastafari knowledge, certified and sealed by the government. Plaintiffs, which is us, the prisoners who were involved in the case, claim that 4 regulations of the defendants who administer prison facilities in New York State violated their rights to free exercise of religion and equal protection of the law. First, defendants cut the ears of all incoming prisoners for the purpose of taking identification pictures. Second, defendants restrict the wearing of the religious quote-unquote crown. Third, defendants do not provide Rastafarian inmates with an ital diet. Fourth, defendants do not allow Rastafarian inmates to hold weekly congregate religious services or holiday celebration. Defendants claim that each of their actions is motivated by a legitimate penological objective. So what that's saying, We put forth that back in them days when we're going at the prison system, and you go there and you have natty on your head, they hold you down and cut it. They literally hold you down and beat you down and cut it. That was done to me. That was done to many others. Straight. And the reason why they claim that they needed the Rastafarian brethren to cut the hair because that they want to get a clear picture of the facial construct in case a prisoner should escape. They did not cater to our meal, which we saying ital food, because basically them serve prisoner what they want to serve prisoner. At the time when we start to go into the prison system, it was basically an Italian pasta diet that exists from because we went into the prison system at a time when there was a transition in the system from a majority white prisoners base to a majority black prisoner base. So that's the reason for that. We could not wear a crown unless it was religiously sanctioned. So they were forcing Rastafari brethren to take off them crown when they were moving back and forth in the system. So that's where the court lay out. Now the court is now going into what they call the procedural history of the case. How the case was brought by the plaintiff, which is us, against the defendant, which is the government, and what's the procedure it went through in the court before it came to trial and then subsequently trial. The action was commenced on January 15th, 1979. Remember, I know? The ruling had come down 1989, but the action was first commenced on January 15, 1979. That was when the brethren decided that we're going to go up in the court and try to defend the right of Rastafari throughout the entire United States of America. The action was commenced on January 15, 1979. It was dormant from April 1980 to March 1985. So from 1980 to 1985, the court had dragged them foot. The prisoner dragged them foot. You have to file this. You have to bring this. You have to pay this money. You have to do this. Dragging them foot. So from we filed it January 1979. From 1980, 1 year later, to 1985, this case remained dormant, while settlement was discussed unsuccessfully. So when we file the complaint in the court, the judge basically said, all right, uno prisoner and uno will represent the government and the prison. Uno go say if uno can't come to agreement without we, the court, getting involved in it. That couldn't come to because the prison and the state and New York decided to them now give the prisoner them Rastafari nothing. You have to cut on a year, you have to nyam where we going to eat, you now we no crown and you now meet and gather and give praises. So it was unsuccessful. In May 1986, the parties stipulated to certification excuse me, of a plaintiff class consisting of all persons who are or who shall be committed to the care and custody of the New York State Department of Correctional Services and confined in facilities under its jurisdiction and control, who sincerely profess to observe and adhere to the tenets of Rastafarianism. On August 1929, 1986, the court granted plaintiff motion for a preliminary injunction prohibiting DOC's, Department of Correction, from cutting the ear of class members. And in that injunction that was issued by the court, said, hold up, before we go to trial, and this may take years to go to trial, the judge basically said, one, I'm going to recognize that these prisoners and this piece of people represent all prisoners and people in a society who suffer under them consequences, yeah, or who shall suffer in the future. That's what you hear me just read. And them issue that order in a case named Benjamin versus Conglin, and you can find that in volume 643 of the Federal Supplement, page 351, Southern District of New York, 1986, before we went to trial. On June the 30th, 1987, defendants, which is the prisoner, the state, and the prison people, and the guard, them and all of them, filed a motion to vacate the preliminary injunction. The motion had been consolidated with the trial of the merits and plaintiff claim. So even before we went to trial and the judge them said, all right, stop cut them on them here. Knock that off. The defendants, the government of the United, representing the government of the United States and New York State said, we don't want to abide by that. We still want to cut here. We still want to cut here. And the court has let them know, now that now go on. We are going to stop it. Till we go to trial and we make a final ruling. Continue now. A bench trial was held on August the 31st, September 1, 2, and 3, 1987. So that's when the case went to trial. August 31st. And it commenced through September 1st, 2nd, and 3rd, 1987. The court heard testimony from 8 inmates class members. The first one, Jaboni. See him badass on the year upon the radio program there. Him lead it. Him are the number one Rastafari and expert who testify on this case. Ernest Desire, David Daly, Edward Jameson, Ernest Nurse, Wayne Overton, Alfredo Lewis, and Marlon Clark. Plaintiff's expert nutritionist Bob Leroy, right? Defendants Thomas Coughlin, Superintendent of Docks, and Philip Coombs, Deputy Commissioner of the Department of Correctional Services Facility Operation. The Reverend Earl Moore, Department of Correctional Service Assistant Commissioner for Ministerial and Family Services. Elizabeth Van der Wal, Assistant Director for Nutritional Services. And Louis Passara, of the Department of Correctional Services, Director of Correctional Nutritional. So these are all the people who testify in the case, both for and against the challenge that was made to the government. Well, we reach the part where the heading now I deal with discussion. The first, this is the court, the court will lay up the whole history of the case and they will give him discussion now. The First Amendment to the Constitution states in part, quote, Congress shall make no law respecting an establishment of religion or prohibit the free exercise thereof, unquote. Every prison inmate retains those First Amendment rights that are not inconsistent with his status as a prisoner or with the legitimate penological objectives of the correction system. So as long as where you have to practice your religion does not hinder the prison people them from carrying out them legitimate right, you retain all of your religious rights that you went from the street into the prison with. And there were cases that laid out that principle. Well, Pell versus Pocona, right? That's one of the cases. Bell versus Wolfish, that's another case. Price versus, these are other people over the years who have challenged certain things from their particular religion, say them have a right for prayer. Them have a right to do certain things. And the court had made that recognition in those cases years earlier, certain basic things. But because we as Rastafari was new to the system, the prison system and the state government and the federal said that right wasn't a part of prerogative because we don't recognize . Continue. Recognizing that courts are ill-equipped to deal with the increasingly urgent problem of prison administration and reform, the Supreme Court has tempered the scrutiny of challenged prison regulation. Well, then basically they said, because prisoners rough and the prison guard them have problem controlling prisoner, the court try not to intervene too much in how prison people run them prison. Because prisoner unruly. And the court don't have the everyday knowledge of how prisoner conduct themselves and how prison guard conduct themselves. So what them do? They give the benefit of the doubt to the prison guard that the prisoner them always wrong. So when I intervene, when them bust a prisoner head and violate prisoner right, including them First Amendment right to practice them spirituality. And the court go on by saying, subjecting the day-to-day judgment of prison official to an inflexible, strict scrutiny analysis would seriously hamper their ability to anticipate security problems and to adapt innovative solutions to the intractable problem of prison administration. Again, this is the court position from longer time. When I intervene in how prison guard should conduct themselves with prisoner, because we're not there if you know how prisoner misbehave. And we know prisoners are people you cannot be trust them. Them are criminal. Them going smuggle drugs. Them going fight. Them going stab. Them going thief. And as judges, we and the outside judges don't understand the everyday activity. So we're not going to regulate the prison guard conduct too much. So over the hundreds of years, these were cases that were developed through the judicial system where basically gave prisoners no right. Alright. The court went on. In Turner, a previous case, the Supreme Court identified 4 factors relevant to whether a challenged prison regulation is valid as reasonably related to legitimate penological interests. The first is whether there is a valid, rational connection between the regulation and the government interest put forward to justify it, which must be legitimate and neutral as to content. Basically, whether or not when somebody challenges something in the court, whether it have any legitimacy and whether it will infringe upon the prison guard them ability and responsibility to protect society from the prisoners. The second is whether alternative means of exercising the right remain open to inmates. Alright, so basically, if you ask the prison people, say we have a right to go worship. And the prison people say, no, we don't want to not congregate, because when I congregate, a ganja on the down there smoke, and down there plot and scheme against the prison guard them, and down there plot and scheme against other prisoners. The court is saying, all right, if that's the prisoner's position, if that's the state position, if that is the government position, what is the alternative? How can we allow these people to still practice and have congregate service without leveling any type of threat to the security of the prison? So the second is whether alternative means of exercising the rights remain open to the inmate. The third consideration is the impact that accommodation of the claim rights would have on guards, other prisoners, and the allocation of prison resources. Finally, the absence of ready alternative is evidence of the reasonableness of a prison regulation. While the existence of easy alternatives may show that a regulation is not reasonable, but is an exaggerated response to prisoner counsel. So the court are laid out, right? When the court is going to consider how to approach a prisoner's claim that their rights has been violated, and in our case, or denial of our religious right, which was guaranteed by the First Amendment of the United States, is 1, whether what you're asking for is reasonable. 2, whether it will infringe upon the guard them ability. 3, whether there is an alternative. And 4, whether the people them, the defendant them, the prison guard them, and the who run the prison and who run the government is really just putting up objection because they want to put up objection, and them objection is not legitimate. So them they are the 4 and 5 steps where the court have to consider in making. Right, now the next heading where we come to is the challenge regulation. So the court will address now the issues that we as the Rastafarian brethren, and it cover the Rastafarian sistering too, who then are the woman prison. So we don't act like we have to get them. For them right come up under this. So this is the court now going to deal with the beef where we carry to them. The first one where the court will address is the initial haircut, where once you get convicted and then put you upon the bus and carry you going to the prison system, the very first day of your age, then hold you down and trim you, whether you want to do it or not. So the court entitled it, the challenge regulation number 1, the initial haircut. Now listen now. Many Rastafarians take the vow of the Nazarite, never to cut their hair or beard. Inmate witnesses testified that the wearing of dreadlocks is a consecration and a covenant with God. The source of the belief is both biblical, identified by inmate witnesses as Leviticus 6, Numbers 6, and symbolic of Haile Selassie, whose Nyabingi warriors wore their hair in dreadlocks. The matted look of the hair is symbolic of a lion, and therefore of Haile Selassie, who is revered by Rastafarians as the Lion of Judah. The vow is of central importance to most Rastafarians. Ernest Nurse testified that the wearing of dreadlocks is very holy. That can be found on page 278 of the volume of the book. The quote continues. Not all Rastafarians take the vow of the Nazarite. 3 groups that are located in Jamaica: the bearded men, 1, the clean-shaved men, and the Comsum tribe do not wear dreadlocks. All of the prisoners who testify wear their hair in dreadlocks. So basically, we are cover everybody. Those who trim and those who don't trim. Those who shave and those who don't shave. Because one I think when I want to go into the court, we never want to go into the court and separate Rastafari amongst ourselves. So we are going to cover everybody. Now, Departmental Directive number 4914, what happening now? When you go into the Department of Correction, matter of fact, any government agency, what you will find is that they have directive, rules and regulations that govern just that department. Whether Department of Agriculture, Department of Education, Department of Health, Department of Correction, every government agency in Jamaica, anywhere in the world, they have directives that show you how the workers in that department must conduct themselves in relation to themselves and in relation to the public or the prisoners. So the one we're dealing with now is the Prison Departmental Directive number 4914. And this directive requires that all male inmates submit to a haircut and shave for the taking of an initial identification photograph. Defendants, which are the police them, argued that an initial clean shave, short hair photograph is necessary for security reasons. Deputy Commissioner Philip Coombs testified that a clean-shaven, short-hair photograph is necessary to show the inmate's facial and cranial structure, which are important identifying features in case of an escape. Remember I said that earlier. Because a fugitive could radically alter his appearance by cutting his hair. This man testified that a picture with the inmate's dreadlocks pulled back is not adequate for identification purposes, and that the Department of Correctional Service has experienced security problems with other inmates who feel that the Rastafarians are being given special treatment. So this man who represent the government and claim say, him can get a clear facial picture of a prisoner even when you pull the locks back as tight as can and tight. Because when them, if and when one of them should escape, all them do a cut off him locks and we can identify him. That is what I say. And them also say, if the court grant Rastafari the right for wear them locks and don't cut the brethren and brethren them ear, then other inmate will get jealous and say, oh, me can't wear my ear in a locks, but them people over there so can. So that's them twofold argument. One, them now will get a clear picture of the prisoner face in case of escape. And 2, other prisoner going to get jealous if them can't wear them ear or Rasta wear for them. The haircut issue has already been determined adversely to defendants in 2 state court cases. So what the federal court has said that yes or no is that while we did have the case in the federal court, some other brethren did also carry the case in the state court. In the court, they only deal with New York State. Remember, state court only deal with New York State. Florida State Court, they only deal with Florida. Pennsylvania State Court only deal with Pennsylvania. Okay. So some other man, even though this case when I read up with carrying at the federal court will cover the America, some other brethren did challenge the haircut cleaning at the state court. So the court has said the haircut issue has already been determined adversely to defendants, mean against the prisoner, mean against the prison guard them, because the prisoner them winning in 2 state cases. Lewis versus the Commissioner of the Department of Correctional Services, right? That's one of the cases where them do win, and Overton versus the Department of Correctional Services, right? So them they are the 2 state level cases. We only do that cover New York State where the state court says stop cut the man them here. We are going to watch what the federal court are going to say. And when the state government appeal them 2 state cases, the court dismiss it. Alright. This court, we are talking about the federal court where the judge are talking now, Judge Stanton, he said, this court determines in August 1986 that defendants are precluded from relitigating the issue by the doctrine of collateral estoppel. Benjamin, volume 643 of the Federal Subsidiary. Defendants have failed to convince the court that that determination should be changed. So what basically the judge is saying is this: until I make my final ruling, we will not cut the man them here again. We make the final ruling, and then we go. I just stand and go make the final determination whether we going to have the right to cut the man them here or leave the man them with them locks. The defendants, remember anytime I say defendant, we don't use always I used to call prisoner defendant. Well, in that case, I know prisoner them are the defendant. We were the plaintiff. And the prison guard and the prison administration and the state government and the federal government, them are the defendant now. The defendants argued that non-mutual offensive collateral estoppel should not be applied against a state government. In Mendoza, another earlier case, the court held that such estoppel should not apply against the federal government because of the nature and number of cases that the government litigates and the fact that policy consideration may determine whether the government will appeal an adverse decision, unlike a private litigant. And then pointing to the Hercules carrier, the court applied, which is another case, the rationale of Mendoza to state government. The court relied on the fact that plaintiffs were seeking to preclude a state agency from relitigating an issue that had been previously determined in an administrative proceedings brought by a separate state regulatory agency. Now, what is collateral estoppel? It's a Latin term where basically say once the court argue an issue already and make a final decision, the court don't want to hear it again. You don't go one side with that. Unless there is something, you can point out something wrong in the decision, the court don't want to hear it. So that's what collateral estoppel be. So basically, when the state government did say, stop cut them on them here, and then the federal government step in and say, yes, I agree with the state government, stop cut them on them here to make a fine. The state, the Department of Correction try to go back in the court with it, and the court said, we don't want to hear it. Collateral estoppel mean we addressed that already. We don't want to hear it again. And where the government representative and the Attorney General was saying that you're not supposed to apply collateral estoppel to government. That means government can come at you a million times if they feel like the court has said no. You're not going to come at the people a million times because they don't feel like. Because what will happen in a situation like that? When a plaintiff win a case, or a prisoner win a case, all we have to do is keep bringing things in the court till you find a judge, you go shop around for a judge, till that judge come and rule in our favor. So we're not going to entertain them entirely. The decision to apply offensive collateral estoppel must be made with discretion. Here, the same state agency, the Department of Correctional Services, the prison, litigated and lost the issue in the state court. The agency had a full and fair opportunity to litigate, and the identical issue was actually litigated and actually decided. The agency was aware that this action was pending at the time the state action were decided, and so had a strong incentive to appeal the adverse decision. Therefore, it is not unfair to prevent defendants from relitigating the issue in the case. So, when you go to the state and when you lose, when they know the same argument that I make on the federal court, when you appeal up because you believe you don't get 2 bites at the apple, and the judge say, you don't get no 2 bites at the apple, you don't get 1 bite, you should swallow the whole apple. If that's what they want. Court continue. Even if the Department of Correctional Services were not precluded from relitigating the issue, Departmental Directive 4940 does not withstand scrutiny under the analysis set forth in Turner in an earlier case. Applying that analysis, one must grant there is a rational connection between the haircut requirement and the security objective put forth by defendants to justify it. Equally apparent is that alternative means of exercising the rights do not remain open to plaintiff. Defendant argument that an inmate may regrow his ear to any length after the reception haircut misses the point of the violence done to his religious belief when his ear is cut. So what the court basically say is one, we claiming that you need a clean facial cranial picture of a virgin when get arrested with locks, and therefore you need to cut him ear. The court basically said no. Because right after you cut it, the man can grow it back, and the man will grow it back. You understand? And it misses the point. Is the argument where the court is saying is not so much whether you can get a cranial picture or you cannot get a cranial picture. Because the lower court has determined that yes, if you tie the locks back tight enough, you can get the full face picture. But also the court is saying, what about the violence that you're doing to the prisoner when you have to hold him down and cut him here based on a religious belief for him have, and the ability that you not recognizing that religious belief. Defendants argue that the accommodation impact is great because Rastafarian inmates must be segregated at reception and procedures either first or last, and that other inmates resent they are being given special treatment. However, the accommodation impact is no greater than the practice prior to the entry of the preliminary induction, when Rastafarian inmates who refused to submit to a haircut were segregated and placed in involuntary protective custody or had their haircut by force. So the court addressed the violence and the denial that was inflicted upon the brethren when they refused to cut them hair. I mean, I already lay out in my autobiography. What did happen to me? I get mashed down because I refused to comply with them directive. All right, continue. The decisive factor in the analysis of the haircut issue is the availability of an obvious, easy alternative. The photographs that were submitted to the court showing the inmates' ear pulled back in a rubber band or a earnet demonstrate that such photos are adequate for a security purpose. They show clearly the facial structure and features, and I find Mr. Coombs' testimony to the contrary unpersuasive. That he must say, him not believe what the man that testify that them can't get a clear picture without the haircut. The judge has said him not find him believable. The availability of this easy and practical alternative demonstrate that the regulation is an exaggerated response to the perceived escape threat. That conclusion accords with those repeatedly reached by the New York State Court when the issue was presented to them, that the asserted objective of the regulation in issue could be fully achieved simply by pulling his ear back when the initial identification photographs are taken, and that directive number 4914 constitute an impermissible infringement of the plaintiff's constitutional right to fully exercise their religion. And then them quote the case Overton, which is Overton versus Lewis. And this can be found in the book, volume 133 of the Appellate Division, 2nd edition, at page 745. So the court, the federal court starts to make its ruling now. It says, you don't need to cut the man here. You don't need to cut nobody here to get a clean picture in face. You can use a rubber band and tie it up at the back of his head and take the picture, and when he done, him can take off his rubber band. Simple as that. The court continues. Plaintiffs would prevail on this issue even in the absence of the preclusive effect given to the state opinion, and plaintiffs are entitled to a permanent injunction on the issues. Wherefore the court is ruling now. Judge Stanton is saying, henceforth from now on, you're not cut nobody here. By Rastafari, we are coming at the penal system. Now, the judge is now going to the crown. One time when we're going at the system, we couldn't wear a crown. You have to take it off. Them now respect man, religious and spiritual rights for cover them locks. The court will address it now. The crown is worn as a Rastafarian tradition to keep impurities from the dreadlocks, to shield them from the eyes of non-Rastafarians, and to keep the curious from touching them. Not all Rastafarians wear crowns, and those who do vary in the degree they observe the practice. Most crowns are large, loosely knit or crushed circular wool caps, many in the green, red, and gold of the Ethiopian flag. However, Rastafarians wear hats of other descriptions to cover their dreadlocks. Defendants, we attack again when you hear defendant, is the prison officials them and the state government and the federal government. Defendants contend that the crown is a security risk. The large, loosely crown may be used for hiding contraband. Searching the crown necessitates increased contact between guards and inmates. The increase in close personal contacts in turn increases the threat of confrontation between guards and inmates with its security risks. So basically, where the government and the prison people says, we don't want the virgin them wear no crown because they are going to hide drugs and weapons in it. And by we have to search it, they might come in close contact with us, and that will lead to confrontation and fight and stabbing and cutting. So therefore, don't make we wear no crown. Prohibitions on wearing the crowns are not uniform throughout the Department of Correction. For instance, David Daly testified that at Greenhaven, a maximum security facility, he is allowed to wear his crown everywhere but in the mess hall and the visiting room. While Edward Jameson testified that he was not allowed to wear his crown anywhere at Wyoming, that's the name of another prison, a minimum security facility, or Lincoln, a minimum security facility. So these brethren are testified to the crown say, in some prison, they may allow you, they may not pay you no mind, they may just turn them eye and watch you go through. But in a one situation, they don't want you waiting at a mess hall and they don't want you waiting at a visit. You go to the next prison, you can't wear it, period. So some prison did enforce the rule where you can't wait and some never did enforce it. Application of the Turner four-part test demonstrate that defendants' regulation governing the wearing of the religious crown do not impermissibly infringe on plaintiffs' First Amendment rights. So basically, they must say, by them telling us we can't wear a crown, it now violates the First Amendment right to practice your religion. There is a valid rational connection between the prohibition on crown in certain areas and the security interest put forward to justify it. The crown is a large, loose-fitting cap that may fairly readily be used for concealing and transporting weapons, controlled substance, or other contraband, thus posing a threat to prison security and the safety of other inmates. Plaintiffs argue that the regulation is not neutral because Jewish and Muslim inmates are allowed to wear yarmulkes and kufis throughout the prison. However, yarmulkes, that are where the Jew them, so-called Jew them wear, and kufis, where the Muslim them wear, so-called Muslim them wear, are smaller and fit closely to the head, while the crown is of a size and shapelessness which would facilitate uses which are legitimately forbidden. So the prison guard and the federal government and the state government them at that time, we are defending them says, we now make the rest of them wear them come because it's too big. Them can hide knife and gun and drugs and everything up underneath it. And the reason why them allow the Muslims and the Jews to wear for them is because for them one small and just sit up on top of them head, so they don't have the space for hide no drugs. Right? Alternative means of exercising the rights are available to the inmates. This is the judge rule again. They are allowed to wear the crown in their cells and at other times and in other areas that the prison administration determines do not pose a security threat. The fact that regulations and the wearing of crowns differ amongst institutions reflect responses to the different security concerns of each individual institution, illustrating that this is an inappropriate area for the court to substitute its judgment for those of the prison administration. The accommodation impact on the guards and other prisoners would be substantial. The increased number of searches that would be required if inmates were allowed to wear their crown at all times would threaten increased confrontations between the guards and inmates, perhaps requiring a reallocation of prison resources. There appears no easy alternative to the restriction. This may simply reflect the fact that already the crown is allowed in many areas, indicating that the most workable judgments are in place. Then he make reference to some prior case. In Standing Deer versus Carlson, the court applied Turner four-part test and upheld a prison regulation that forbids the wearing of a religious headband by Native Americans in the mess hall. So some Native American they go to court and say them want to wear them religious headband going at the mess hall, and the prison people them deny them. The court held that it is clear that the dress regulation involved in this case is logically connected to the concerns of the cleanliness, security, and safety that were invoked to justify it. The court rejected the prisoner's contention that increased inspection provided an easy alternative, holding that the security threat posed by increased guard-to-inmate contact would adversely affect penal objective. Plaintiffs have not met their burden of showing that the restriction and the wearing of the religious code impermissibly infringe on their constitutional right. So basically, at a part of the ruling, the court has said basically, when you go on and wear things, and then whatever the prison decides to do in terms of searching or not searching. But eventually, what did happen in this case? Everyone was allowed to wear them crown. And you could have wear whatever you want to wear. Now the court went to the ital diet. It have addressed the argument where we put forward in the court to deal with the food. Ital symbolizes a belief in life and an avoidance of symbols of death. Individual dietary practices vary widely among Rastafarian individuals and sects, both inside and outside prison. In general, Rastafarians do not eat meat and almost universally refrain from eating pork. Most Rastafarians abstain from alcohol and caffeine. Some Rastafarians do not eat fish, and some refuse dietary products. Some refrain from eating any food that have been processed, particularly canned food, believing that the can symbolizes a coffin or death. Some Rastafarians refuse to eat vegetables that have been cooked for more than a few minutes, believing that overcooking destroys the food's natural value. Rastafarians also object to vegetables that have been treated with non-organic pesticides or fertilizers. So that's the argument where we put forward in the court. We ask them that the prison provide us with ital food. Who want to eat meat, but make an alternative for those who do not want to. Some Rastafarians would only eat food that is prepared and served in pots and bowls made of natural materials. More specifically, clay pots and calabash bowl. Some Rastafarians will eat only food that they have prepared themselves. Others refuse food that has been prepared by a woman during her ministerial period. Some of the inmates who testified eat meat, dietary product, fish, canned food from the commissary, and bread made from processed flour. Whenever pork is served, the Department of Correctional Service provides a meat substitute to all inmates to accommodate the religious requirement of Jewish and Muslim prisoners. No such substitute is offered when other meats are served. They also offer a kosher food program at Green Haven Correctional Facility and a neutral diet at other facilities to inmates who have been in the Green Haven program. Most of the vegetables served in the Department of Correctional Service institutions are canned or frozen because they are more cost effective and because fresh vegetables are not available all year. Vegetables are prepared by steaming for a maximum of 15 minutes. The use of clay or calabash pots and bowls is impractical because clay is breakable and it violates New York's food preparation regulation, which forbids the use of wooden working surfaces other than hard marble. Porous materials can retain and breed harmful bacteria. So basically the argument is that we're not going to allow no calabash and all them things there because it have pores in it, it have small hole in it where you have to use microscope to see. And them things, the food go up in it and it breed up germs and them no want it in them prison. It would be both expensive and a severe administrative burden for defendants to provide Rastafarian inmates with a diet containing only natural foods and nutritionally adequate meat substitute. Other prisoners understandably resent special treatment that is given to any group, and the possibility of tension and confrontation is particularly troublesome at mealtime, which is often the only time the entire prison population is together. So basically, the court has said, and from the state, the government, and the prison guard position is that ital food too expensive. We not give them no calabash bowl because it may keep bacteria in it and affect the whole prison population. And three, other inmates are go jealous if them say Rastafari I get them ital food and them not get for them special food. Defendants provide Orthodox Jewish prisoners with kosher or neutral meals. They provide special meals during Ramadan and meat substitutes so that Muslim prisoners can follow their religious prescription against pork. To that extent, they do not appear neutral as between Jews and Muslims on the one hand and Rastafari on the other. Where the quote says, we not cater special food to Jews and Muslims, but we not talk about it when we go to special problem if we don't give Rastafari our own food. But the inequality of treatment, if it is perceived as such, reflects the fact that it would be much more difficult to accommodate the Rastafarian because their definition of an ital diet are so varied. The complex of the diet restriction that plaintiff described would impose undue financial and administrative burden on defendants to provide an ital diet that met with the religious views of every Rastafarian. So what the judge basically says, there is no one diet where all Rastafari adhere to. And if the court, and as to where the virgin them testify, like, it's like every Rasta eat where them feel like eat, but them want ital diet, and that too much we provide to everybody. The man they eat this, the one they don't eat this, the one they want this, the one they don't want this. The court has said we're not going to impose that upon the prison people. But I tell you what came out of this case eventually. Eventually they have created a meatless diet where whenever you go to the mess hall, even to them in the prison them, especially in New York State, them always have an alternative to meat. So if you don't want to take the meat, they may have soya bean this and soya bean that or whatever. Plaintiffs do have alternative means of exercising the right. They may receive food from the outside through the prison package room, and they may buy food at the prison commissary. They may also abstain from eating any food provided in the mess hall that offends their religious belief, although it may not be acceptable to all Rastafarians. Those who do not reject all dietary products may obtain a nutritionally adequate over-lacto included eggs and dairy product diet, even abstaining from all meat, fish and poultry, and then emphasize reference to a case pertaining to that, where prisoners requested from a natural food diet based on sincerely held belief refused on the basis that it will create undue costs and administrative burden and have a potential disruptive effect upon the prisoners. So where the judge basically says, so now, and this was before them create the ital diet in the prison. If you don't want to eat the meat, you can go to the prison shop and buy your ital food, or you can get your family send it to you. So that was the alternative. In a case named Kane versus Carden, the court held that the state must provide kosher meals to Orthodox Jewish inmates. Factually, there were few Orthodox Jewish inmates in the custody of the Department of Correction. Further, Kahane sought meals that comply with the laws of Castro, which are more well-defined than the dietary practices described by plaintiff. Defendants' practices here do not run afoul of Kahane. Read in the light of Turner and Olin, two other cases. Judges say if you look on them two other cases, they not really violate the full law. Nor do they impermissibly infringe on plaintiff's First Amendment or equal protection. So the court basically say, if you don't want to go to the mess hall and eat the prison food, what you can do, you can go to the prison store and buy on the own ital food and hook it up. Or you can ask on the family if you send them packages. That was all the court ruled. But like I said, eventually, the court came around and the prison department came around, and today when you're going at the prison system, there's an alternative meal being provided to prisoners for those who don't want to eat meat. Now the court in its fourth ruling now goes on to address congregational service. Does the Rastafarian virgins have the right to meet and worship as they see fit? Here's the quote. Congregate religious services in Jamaica. Weekly congregate services last for 2 days and holiday celebration lasts for 2 weeks. The nature of the services that are held in Jamaica and the type of services that the prisoners seek is unclear. The Department of Correctional Service has available no body of established religious doctrine on which it can rely in determining the particular ritual or practices which are appropriate to the Rastafari, meaning that the prison department don't know how Rasta practice them religion, and because them don't know how them practices, them figure say prisoner go meet and go on with all type of illegal activity, stab and cut and sell drugs and plot and scheme against the prison. Marlon Clark, a prisoner, testified that a typical prayer service in Jamaica would be presided over by an elder and would involve singing, dancing, chanting, and biblical reading. Ernest Nurse testified that a typical prayer service would consist of psalms reading, prayer, and Bible discussion. Jaboni, the same badass out of England, testified that meetings of Caribbean African Unity, a Department of Correctional Service approved cultural organization, begins and ends with a prayer, and that a typical religious service would consist of an opening and closing prayer, reasoning, and playing of drums and chanting. So when Jaboni really says this, there's an organization where I did starting at the prison and it's still functioning today, we name the Caribbean African Unity Organization. And this is an organization we're supposed to umbrella all black people from the African continent and throughout the Caribbean. And basically anybody black who want to join, anybody from these regions, you don't specifically have to be black, but anybody from them region can join it. And so happen that most of the people from them region, they are black people. That's why Jaboni make reference to that, because when we used to keep meeting them at the CRU, we walk with a chant, and when the meeting done, we close with a Rastafari chant. The Department of Correctional Services will allow Rastafari to hold congregate service when and if an outside sponsor comes forth. Requiring a sponsor from the outside is a reasonable method of authenticating and maintaining the integrity of the spiritual purpose of the meeting and its practices. It comports with the institutional responsibility to see that the religious services are genuine and bona fide, and not used as an occasion for extortion, for the holding of kangaroo courts, or for the dissemination of conspiratorial information. The free world sponsor requirement has been upheld for the same reason given by defendants, and they make reference to some other cases, Addy versus Ann and Tisdale versus Todd. Its purpose is not to enforce doctrinal conformity as plaintiff protests, but to assure that the inmates' meeting serves its professional religious purposes rather than temporal ones which might threaten society. Section 16 of the New York Correctional Law provides that religious services, quote, from some recognized clergymen of the denomination, unquote. So basically what the court rule is Rastafari have the right to meet. But the only way then we make we meet, we have to bring in a facilitator, someone from the outside who know the religion, who will come and oversee that basically the congregation abide by the rules of the Rastafarian practice and not down there stab and cut and sell drugs and use drugs and plot against the prison. Them no want that. So them never trust inmates to conduct it. Not long when an inmate start doing it, you know. But up to the time of the ruling of this court, them want to bring in somebody from the outside. At this time of the ruling, no sponsor has come forward who has been approved by the Department of Correction. Caroliani, an associate professor of anthropology at York University in Toronto, offered to organize a holiday separation, but Dax reasonably refused on the basis that she is an academic, not a religious authority. Mr. Dale testified that the tenets of Rastafari do not allow a woman to lead services for men. The Reverend Earl Moore, this is from the Department of Correctional representative, testified to good faith attempt he has made to locate and obtain the services of a sponsor. So basically the court rule that Rastafari have a right for meet and have congregate service. But they only go and allow it if you find somebody from the outside for come in and deal with it. Now when segue a little bit, you have to tell what happened when we try to reach out. When the court rule and so we must find somebody from the outside for come in, we contact the 12 tribe of Israel representative in Queens, New York, and ask them if they would have come in as a facilitator and help conduct Rastafari service. The 12 tribe request, the 12 tribe response to our request was that no Rasta no they are prison. That means them now recognize the man who go to prison as Rasta. So them now come in. We contact the Nyabingi them and ask them if them could have come in. One brethren who did in the house when them receive the letter, you know him tell me personally say, him say when the mailman bring the letter come and them see it come from prison, them throw it straight in the garbage. Them don't even open it. The funny thing is, after we win the case, you'll be surprised to see how much 12 tribe and Nyabingi come in and look for service. Even the one who did in the house or throw the letter in the mail. You see how life go? That is how life is. Today you're up, tomorrow you're down. Now, when we request that prisoners conduct the service, of course, nor would the use of inmate religious leaders be acceptable, because inter-inmate leadership struggle pose a security problem, meaning that man are going to fight for leadership position. This is what the court has said. So them not allow no prisoner to lead it. Although some Muslim services are led by inmates, imams, they are supervised by outside imams. And the Department of Correctional Service ministerial personnel have an outside resource to contact concerning religious issues. In addition, Philip Coombs testified that the Department of Correction is hiring more outside imams to lead services in the prison because the use of inmate imams is a security problem. Finally, defendants object on the ground that Jamaicans' dialect would be spoken during religious services and that they would have no way of knowing what's being said or control what went on during the service. So basically the prison authority and the government and the federal government, everybody are saying, we don't want no prisoner conduct no service. Because when them are talking in them Jamaican language, we not, them as prison guard now go understand. And them would have plot and steam about drugs and robbing and killing and whatever. So them was against prisoners conducting the service. The court continued. There is a valid rational connection between defendant's security concern and the requirement that a religious group have an outside sponsor in order to conduct congregate religious services. The requirement applies to all religious groups. Then the court continued. There are alternate, although limited, means of expressing the right that remains open to prisoner. They may pray individually in their cells and may reason with other inmates in small group. Mr. Daly testified this was an adequate substitute for a prayer service. The meetings of the Caribbean African Unity begins and ends with a Rastafarian prayer. No other easy alternative appear feasible. Under the circumstances, the Department of Correctional position that congregate services await only the presence of an outside sponsor comport with Turner and Olaine, two other cases that required it, and represent a reasonable peniological restriction. So basically, the court is ruling the prison find a security risk if they allow prisoners to conduct the service. Therefore, we must find somebody upon the outside. What eventually happened after the court ruling that almost all of the prison are the prisoners them conduct the service now. And there is no threat to them security system. And at the same time, there are outside sponsors who are coming in, even though not enough, who are helping conducting the service to appease the concerns of the Department of Corrections. So now the court now reached down to the final conclusion of its ruling, and we're going to touch upon it. Conclusion. For the foregoing reasons, defendants, listen carefully now, this is the court that issued the final statement on the Rastafari case. For the foregoing reasons, defendants are permanently enjoined from enforcing Departmental Directive 4914 against members of the plaintiff class. The remainder of plaintiff's claims are dismissed. So therefore, I tell them straight out, adds for to the owner can't cut the man them ear again. Defendants are to submit a judgment on consent as to form, if possible, within 30 days of the date of this order. By the same time, plaintiff may submit a counter judgment reflecting matters of form that cannot be agreed upon. Then the court started to lay out certain little notes like footnotes in the argument. Defendants do not contest the fact that Rastafarian is a religion. Defendant post-trial reply memorandum. So at one point, even though there was a point when I recognize Rastafari as a spiritual entity, them start recognize it. Plaintiff do not challenge the requirements of an initial facial shave for identification purpose. So basically is who was shave at that time, them not shave again. Now them can't touch your face, period. Right? Then there was a footnote pertaining to the smoking at chalice, because we don't try to get the right for burn ganja in the prison, you know. And let me say something about this. Because the part where we try to get the virgin them can burn them ganja in the prison, it bring up badass in England. And it bring up a particular memory I have badass in the prison system. When we did a plan for go up in the court and a fight and a look for certain rights in the court, a lot of us, mine, including myself, did have a certain barrier building night where we are tell ourselves, say, no, don't ask this, because if you ask this, the court now go get. Jaboni was never a man of that mentality. Jaboni is a man where say we are asking everything. We are asking all pattern kitchen in the service. We are asking chalice in the service. We are asking ganja. Is a man with no barrier upon his mind. And that make me admire Jaboni. And that make me ride with badass. Because the blind spot them what me have, the restriction them what was in place upon me through indoctrination in terms of when me think society I will accept and won't accept. Badass not buy into that. Badass say, ganja we want burn, we are going to ask it. Make them say no. A judge get paid almost $200,000 to tell you no. Make him tell you no. Don't never you tell yourself no. And this is one of my greatest respect for badass come from. The fact that them thinking capacity is unrestricted. You know what I mean? Say, I agree with everything what him say. But I like to hear the unrestricted mind express itself. Because every now and then I pick up something from it. So basically what we have in the rest of this reasoning here is just footnotes, but is giving clarity to the things that were discussing at the case for all those who will never understand it, while them if them actually reading the physical case itself. So there you have it, brethren and sixteen. Benjamin versus Coughlin, the foundational case for Rastafari, basically throughout the whole Western Hemisphere. Because one thing with the Western world, you know, the European world, you know, whenever them go and make any judicial rulings on any subject matter, them traverse the entire Western world, meaning the white country, them and find out if these white countries has ever addressed this issue before. Is there a precedent? Is there a foundation? Or was the issue approach? So the case here, Benjamin versus Coughlin, where I and I fight, where Jaboni spearhead, where Jaboni was a part of the whole construct of it, is a construct that will never be erased from the history of the United States of America. It's a case where people, prisoners and non-prisoners, use to defend them right. Because it is the first case where the court go constitutionally by the First Amendment through the entire United States. Rastafari is a spiritual thing that must be recognized, that needs protection by the First Amendment. So, me I say this to say, brethren, a lot of men will talk about them rights and them laws, them don't understand how it evolve. Them don't understand that the greatest criminal and civil rights them will come up. We get judicial recognition, started by prisoners. Because when you're there on the street and you're leading a law-abiding life, that type of life they don't challenge no law. That type of life they only benefit from what other people challenge. Some more times the police pull over a man, and the man will say, you have a right to stop me. Did I violate any rules and regulations? Did I do this? He might talk like I am create a lie, but I guarantee if you go look into the foundational, the precedents that set that right, where he might argue fine and Benz is a little prisoner who did that drive and police challenge him and lock him up and him go to court and fight it and get the court to recognize it. People are talking about I have the right to attorney. You know the right for attorney come about? You know that come about? I have the right to confront my accuser in the court and to be a witness for and again. You know where that right there come from? No. A people who's, did I forget, transgress upon, challenge it, and you that has never been transgressed upon can use it as a defensive shield to protect your rights. You know, I'm just to give you a little segue, and I'm giving an analogy to the point where I try to make. For those of you who are Christian, who believe in Jesus Christ, him did have to get nailed to the cross for save you. You see that nailed to the cross when one Christian said Jesus Christ dead for no sin? And the same thing prisoner do. Prisoner get imprisoned and persecuted. So, can't claim so now have this right and that. You think there's a difference? But next time we can go deeper. So, brethren and sisters, that's how the layout of the case. And I hope you learn something from the case. And I hope it was edifying to the brethren and sisters and subscribers. And then I'm going to go further. Not know so much in the case, but I need to go forward to the Promise Key Seminary. I need to go forward. So much things come at me, but that's really my number one priority. And I'm going to go forward, even though I do volunteer work. So, brethren and sisters, until next program, have a blessed time, have a blessed day, have a blessed hour, have a blessed minute. One God, one name, one destiny, peace, love, and unity. Manners and honors. And continue doing the right, man. Bless.